Hello, my dear students. Today, in this presentation, let me discuss the history of Indian company law. Before we go ahead, let us know what is company law and its significance. Company law is one of the most important branches of law. It is that branch of law which governs companies. There is a joint stock companies, or it is that branch of law which deals exclusively with all aspects relating to companies, such as incorporation or registration of companies, raising of capital or allotment of shares, membership in companies, management and administration of companies, conducting of meetings, winding up of companies, etc. Gaining knowledge about company law is of immense value in this era of growing corporate sector. The corporate sector is the most important segment of the country's economy. As already stated, company law is the basic regulatory framework that is responsible for incorporation, regulations, privileges, and restrictions applicable to corporate sector. Therefore, company law is considered as the growth engine of our economy. The company law in India owes its origin to the English Company Law. The various Companies Acts passed in India from time to time were based on the English Companies Acts, of course, with some modifications to suit the Indian conditions. With this introduction, now let us consider the history of Indian company law. The history of Indian company law started with the enactment of the Joint Stock Companies Act of 1850. This act was based on the English Joint Stock Companies Act of 1844. It provided for the registration of joint stock companies as distinct separate entities. No doubt, the Joint Stock Companies Act of 1850 provided for the registration of joint stock companies as separate entities, quite distinct from their shareholders. But it did not confer the benefit of limited liability on the shareholders. Limited liability on their shareholders. The Joint Stock Companies Act of 1850 was replaced by the Joint Stock Companies Act of 1857. The Joint Stock Companies Act of 1857 was based on the English Companies Act of 1855. This act conferred on the shareholders of companies the benefit of limited liability. It is true that Joint Stock Companies Act of 1857 conferred the benefit of limited liability on the shareholders of companies, but this act did not extend the benefit of limited liability to the shareholders of banking and insurance companies. The Joint Stock Companies Act of 1857 was replaced by the Joint Stock Companies Act of 1860, and the Joint Stock Companies Act of 1860 extended the benefit of limited liability to the shareholders of banking and insurance companies. And the Joint Stock Companies Act of 1860 was again replaced by the Companies Act of 1866. And the Companies Act of 1866 was based on the English Companies Act of 1862. The Companies Act of 1866 was intended to consolidate and amend the law relating to the incorporation, regulation, and winding up of trading companies and other associations. Again, the Companies Act of 86 was recast in 1882, and the Companies Act of 1882 was in force till 1913. The Indian Companies Act of 1913 was an imitation of the English Companies Act of 1908 with some modifications to suit the Indian conditions. The Indian Companies Act of 1913 did not take into account the peculiar features of the Indian trade and commerce and the peculiar institutions that were in existence at that time, like the managing agency system, etc. So it was found to be unsatisfactory in the course of its implementation, and it was found unsatisfactory. It was subject to a number of amendments in the coming years. Amendments were made to the Indian Companies Act of 1913 in 1914, 1915, 1920, 1926, 1930, and 1932. A comprehensive amendment was made in the Indian Companies Act of 1913 in 1936 on the lines of the British Act of 1929. Again, from 1937 to 1951, many amendments were made to the Companies Act of 1913. Now, the emergence of the Companies Act of 1956. The many changes that had taken place in the organization and management of joint stock companies after the Second World War, the planned economic development undertaken by the country, and the various amendments made to the Indian Companies Act of 1913 called for a thoroughly revised act, and a committee consisting of 12 experts in various fields under the chairmanship of Sri H.C. Bhabha was appointed in 1950 to review the working of the company law in India. The Bhabha Committee submitted its report in 1952, thoroughly revising the Indian Companies Act of 1913 and its various amendments. Based on the recommendations of the Bhabha Committee, the Companies Act of 1956 was passed. This act came into force from 1st April 1956, the landmark in the history of Indian Companies Act. The Companies Act of 1956 repealed all the earlier Companies Acts and amendments. The Companies Act of 1956 repealed all the earlier Companies Acts and their amendments. Now it may be noted that even the Companies Act of 1956 was based on English company law, namely the English Act of 1948, of course with the necessary modifications to suit the conditions in India. Today, the companies in India are governed by the Companies Act of 2013, another important landmark in the history of Indian company law is the passing of the Indian Companies Act of 2013.